So Scarlet Johansson has sued Disney over terms in her contract for the release of the recent feature film Black Widow. The core of this lawsuit is that she alleges that she was promised an exclusively theatrical release, which allegedly impacts her own bottom line and what she takes home from the movie. And now, reportedly, Emma Stone and Emily Blunt are also considering suing along the same lines for their recent Disney feature films. So in Scarlett Johansson's lawsuit, what are the allegations and what does she need to prove in order to win? And can Disney be excused for the alleged breach because of the COVID-19 pandemic? All of that coming up on Legal Bytes. Hey everyone, welcome to Legal Bytes. I'm Alyte, I'm a lawyer, and on this channel we explain the law one bite at a time. And a really quick thank you to everyone who's watched our videos so far and subscribed to this channel. We recently had a significant boost in our subscribership, and now we are almost halfway to our goal of our first 10,000 subscribers. So if you're watching this video and you're enjoying the content and you haven't done so already, consider liking the video, subscribing to the channel, all the good YouTube-y stuff so that you can know when the next video is uploaded and you can join us on our journey to our first 10,000 subscribers. Okay, let's get back into the lawsuit. So this lawsuit is actually relatively simple on the facts and on the allegations. Scarlett Johansson, also known publicly as ScarJo, alleges basically two causes of action here. And one important thing to note here is that although the contract in question is actually between Marvel Studios and Scarlett Johansson's lending company that she basically uses to contract herself out for various roles through Hollywood, the lawsuit itself is actually between her lending company and the Walt Disney Company. And the reason why that's a little bit odd is because usually when you have a contract dispute, the parties that are involved in the lawsuit are usually going to be the two parties that are involved in the contract. But in this case, ScarJo has decided not to allege any causes of action against Marvel Studios for their alleged breach, but rather against the Walt Disney Company for their interference in the contract. Under normal circumstances, I would expect Marvel Studios to also be named in the lawsuit as a defendant for the alleged breach. There could be multiple reasons for why Marvel Studios is not named in this lawsuit. One of those reasons could be because of ScarJo's apparently good professional relationship with Marvel Studios president Kevin Feige. Another reason could be because ScarJo, or maybe more particularly her attorneys, have determined that by narrowing down the scope of the causes of action, they can streamline the allegations and then give it the highest chance of success. And given what's come out recently in the days following the filing of this lawsuit, apparently Kevin Feige was lobbying to Disney to keep to the exclusively theatrical release, so there may actually be some weight to that. But anyway, let's look specifically at the two causes of action. The first cause of action is intentional interference with contractual relations. What this means is you have party A and party B enter into a contract, and then you have party C come along and do something to frustrate that contract, usually in the form of inducing either party A or party B to breach the contract. So to prove intentional interference with contractual relations, these are the elements that need to be shown. First, the plaintiff has to show that there was a contract between two parties. Second, they have to show that the defendant, who is a third party to the contract, knew of the contract. Third, they have to show that the defendant did something to either prevent performance or to somehow frustrate it and make it much more expensive to perform the contract. Then the plaintiff has to show that the defendant actually intended to disrupt the performance of the contract, or that they knew that it was certain or substantially certain to occur because of their conduct. Fifth, the plaintiff has to show that they were harmed in some way, usually going to be monetarily harmed. And finally, the plaintiff has to show that the defendant's conduct was a substantial factor in causing that harm, meaning if there are other potential causes that came in and were much more important or much bigger factors, that can frustrate the plaintiff's ability to prove this cause of action. So next we have the second cause of action, which is inducing breach of the contract. Now this one sounds very similar to the first cause of action, but there is one important difference. Basically, where the cause of action for interference with contractual relations really only requires a showing that there was an interference with the contract. On the other hand, the allegation of inducing breach of contract requires proof of an actual breach. So let's go through those elements so you can see for yourself. First, just like in the first cause of action, they have to show that there was a contract between the plaintiff and another party. Second, also like the first cause of action, they have to show that the defendant knew of the contract. Third, and here's where it gets a little bit different, is that they have to show that the defendant intended to cause the third party to breach the contract. And then, and this is the distinguishing factor between this cause of action and the previous one, is the plaintiff has to show that the defendant actually caused the other party to the contract to breach the contract. Then, just like the first cause of action, the plaintiff has to show that he or she was harmed. And then finally, number 6, they have to show that the defendant's conduct was a substantial factor in causing that harm. So in this case, ScarJo alleges that she had a contract with Marvel Studios for the production of Black Widow. And according to the complaint, one of those terms in the contract was for a theatrical release. I'll hammer down into the details a little bit more in terms of what it means for a theatrical release in just a little bit. But for now, you can basically understand that a theatrical release basically means that a movie comes out in theaters. Now, also according to the complaint, ScarJo alleges that Marvel Studios would have kept the agreement to have an exclusively theatrical release. However, Disney decided that they wanted to do something different after they introduced Disney Plus streaming. And basically, ScarJo alleges in the complaint that at the time that Disney Plus was introduced as a subscription service, it was a very crowded field with Netflix, Hulu, Amazon Prime, HBO, all kinds of different subscription-based streaming platforms. And so, according to the complaint, because it was such a crowded field, Disney had to figure out some way to induce people to subscribe to yet another streaming platform. And with that, Disney made promises to consumers that not only would the entire Disney library be on Disney Plus, but also they would eventually become the exclusive place for the entire Marvel MCU. Well then, according to the complaint, COVID also happened and movie theaters were shut down, and the release of Black Widow was pushed back several times, all the way up until this recent summer. But leading up to that release, back in March 2021, Disney announced that they were going to be releasing Black Widow not just in theaters, but also on Disney Plus through their Premier Access program. And so the complaint references a couple Hollywood publications that talk about the ways in which having a dual release, on one hand in theaters and on the other hand on Disney Plus's Premier Access, at the same time ultimately cannibalized the box office receipts because people chose to watch it at home on Disney Plus instead. And ultimately, according to the complaint, ScarJo says that she essentially was robbed of all of those revenues because all of that would have translated into bonuses for her out of the contract. And at the same time, Disney actually ended up keeping most profits for themselves because it was through Disney Plus. So ultimately, under this cause of action, ScarJo alleges that she had this contract with Marvel Studios, and Disney then interfered so that they could profit for themselves and take revenue away from Scarlet Johansson. So in this particular case, ScarJo does allege that there was a breach of the contract, particularly when it came to the decision to release the picture not just in theaters, but also on Disney Plus. And so as far as the factual allegations in the complaint are concerned, all of these elements have been alleged. So this is a properly pled complaint overall between these two causes of action. But now that you know what ScarJo basically needs to show in order to win this lawsuit under either cause of action, let's get into the timeline a little bit to see if some of these details might make a difference one way or another. So when it comes to contract law, a centrally important part here is the understanding that the two different parties to the contract had at the time that they were entering into the contract, and sometimes also at various points afterwards if there are various modifications that are made over time. But generally speaking, what we're concerned for here is the understanding at the time of contracting. So according to the complaint, and as we all of course know, Scarlett Johansson made her debut as Black Widow back in 2010. And after starring in a number of Marvel MCU films as the Black Widow, the contract for a feature film starring primarily Black Widow was negotiated. Ultimately, according to the complaint, that contract reached an agreement on May 9th, 2017. Then, a few months later, also according to the complaint, on August 8th, 2017, Disney announced that they were going to be entering into the world of content streaming by introducing the platform Disney Plus. As I mentioned earlier, the complaint alleges that this was a crowded field when Disney got into it. And the reason why that's important is because it introduces a potential incentive for Disney to push Prime content over to Disney Plus and maybe away from theatrical releases. And as that specifically relates to the causes of action in this complaint, that would be evidence that could tend to show that Disney had an intent to frustrate the contract between Marvel Studios and Scarlett Johansson. So moving on, according to the complaint, on March 7th, 2019, Disney announced that they were going to not just introduce their entire library of Disney movies onto Disney+, but that all of the MCU movies would be eventually moved over to be exclusively accessed on Disney+. And ultimately, they intended for it to become the exclusive place for streaming any of the future works provided by Marvel Studios. So in light of that announcement, ScarJo alleges that her representatives reached out to Marvel Studios seeking assurances that they were going to keep to those important terms in the contract for an exclusively theatrical release. And according to the complaint, on March 20th, 2019, Marvel Studios' chief counsel responded. Apparently, he said, "Further to our conversation today, it is 100% our plan to do a typical wide release of Black Widow. We have very high expectations for the film and are very excited to try to do for Black Widow what we've just done with Captain Marvel. We totally understand that Scarlett's willingness to do the film, and her whole deal is based on the premise that the film would be widely theatrical released, like our other pictures. We understand that should the plan change, we would need to discuss this with you and come to an understanding, as the deal was based on a series of very large box office bonuses." But of course, this was before the COVID-19 pandemic, which ultimately impacted movie theaters worldwide. So although Black Widow was initially scheduled to be released on May 1st, 2020, that got pushed back a couple times. And according to the complaint, as of September 2020, it was scheduled to be released on May 7th, 2021, exclusively in theaters. However, ultimately, in late March 2021, Disney announced that they were not going to be releasing the picture exclusively in theaters, but also on Disney Plus through Premier Access. And ultimately, on July 9th, 2021, the movie was released in both venues. And after the box office numbers were apparently very disappointing, Scarlett Johansson filed this lawsuit. So two important questions come up here. The first is, was there actually a breach of this contract? And the second is whether or not COVID actually might provide some sort of an excuse for Disney. So let's start with that first question. So as I've mentioned before in this video, the portion of the contract that's at issue here has to do with the theatrical release of the picture. Specifically, the complaint points to paragraph 2 of the agreement, which says, "The lender," which refers to Scarlett Johansson's lending company, "shall furnish Marvel Studios the services of Scarlett Johansson to perform the role of Black Widow / Natasha Romanoff in the theatrical motion picture currently entitled Black Widow, or The Picture. For the avoidance of doubt, if producer in its sole discretion determines to release the picture, then such release shall be a wide theatrical release of the picture, i.e. no less than 1,500 screens." So when you're interpreting contract language, you really need to look specifically at the words on the page. If they indicate some sense of flexibility, then that contract provision has some flexibility. But in this particular case, that last sentence does seem a little bit firm. Specifically, it says, if there is any release of the picture, then it shall be a wide theatrical release. So what does it mean to have a wide theatrical release? This is actually a term of art which has to be defined for the court. And according to the complaint, Scarlett Johansson alleges that at the time of contracting, both Marvel Studios and Scarlett Johansson, or her lending company, understood that term to mean that the picture would be released exclusively in theaters, and that exclusivity would last for a period of 90 to 120 days. There are two things that they point to show some objectivity of that understanding. The first is that apparently is an industry standard according to the complaint. And the other thing that the complaint points to is basically a pattern and practice of Marvel Studios to release films in this particular way. Particularly, the complaint says, specifically, Marvel Studios' previous feature films had uninterrupted theatrical windows between 82 and 159 days, with an average uninterrupted window of 117 days. Of the 7 Marvel Studios films in which Miss Johansson starred prior to the picture, for which Miss Johansson also received certain bonuses tied to box office receipts, none had a theatrical window shorter than 96 days. So basically, not only is this apparently an industry standard, but as between these two specific parties, this is the way that those releases have been. So if this is demonstrated to be the understanding of both Scarlett Johansson and Marvel Studios of the term wide theatrical release, then it does look like there was a breach of this contract. So this leads us to the other question, which is whether or not the COVID-19 pandemic can excuse Disney from the allegation that they have interfered with this contract. And there is a specific defense which they may or may not use, and that's a term called force majeure. Force majeure, in my admittedly terrible French accent, basically translates to superior force. It refers to some sort of an act or an event that is completely outside of the control of either party to the contract. Most commonly, these are known as acts of God, things like earthquakes, hurricanes, wildfires, that kind of stuff. And in California, which is where this lawsuit was filed, the test for a force majeure is whether or not the external event could have been prevented by either prudence, diligence, or care. Essentially, if it was completely outside of anyone's control. Now, this term has come up since the beginning of the pandemic because of the fact that COVID-19 has disrupted a lot of contracts around the world. For example, think supply chains for toilet paper. But just because the pandemic has existed does not mean that every breach of a contract can be excused by it. Now, in this case, it has in fact impacted the movie industry. However, any defendant trying to use force majeure as an excuse for breaching a contract, for example, has to show that they have done something to try to mitigate that force. And of course, those mitigations have to be done in good faith. So in this case, the complaint does allude to the fact that there were several amendments to the contract. It doesn't say exactly what those amendments were for or what any of the terms were. However, we do know that amendments did happen. If those amendments to the contract had to do with pushing back the release of the film because of the pandemic, that could indicate some level of mitigation. However, an argument could be made for the proposition that that mitigation arguably needed to go further and not frustrate the contract entirely by releasing the film in 2 different platforms, which basically would mean that Disney would not be excused here. And ultimately, I guess the question here is whether or not Disney or Marvel Studios could have done something that would have continued mitigation of the COVID-19 pandemic and its effects on theaters, and at the same time that doesn't actually breach the contract. So there you have it. That's Scarlett Johansson's lawsuit against the Walt Disney Company. What do you guys think? Was there a breach of this contract between Marvel Studios and Scarlett's lending company? And do you think that COVID may or may not excuse Disney's conduct? Let us know in the comments below. Otherwise, I hope you found this interesting or at least informative. And if you did, we would love it if you would hit the like button. It does help us with the YouTube algorithm gods.
Oh no. You brought the monster.
So, Banner. That's your play.
What?
Loki means to unleash the Hulk.
And seriously, if you've gotten to this point in the video and you haven't done so already, consider subscribing and hitting the notification bell. That way you can find out when the next video is uploaded. See you in the next video.